Farm Owners Association of America encourages everyone to watch the full-length version of our context training presentation, but many small business owners are simply too busy to watch it in one viewing. So Team POAA is also making context available in 5 short episodes as a convenience to anyone who wants to learn some basic business law principles by exploring the context of our association's objections to a proposed settlement of 3 employment misclassification class actions. To be clear, if you're a current owner operating in California, Illinois, or Massachusetts, whether or not you want to opt in, opt out, or object to the proposed class settlement is a decision for you and for you alone. If you operate your business in any of the other 47 states, you may want to consider hiring an attorney or joining POAA and seeking permission from the court to intervene and object to the proposed class settlement for reasons we addressed throughout the presentation. Please, we encourage everyone to watch all 5 episodes. Okay, everybody, please stay in your seats, hang on to your hats, and let's try to make some sense of all this legalese so you can decide whether to opt in, opt out, or object to the proposed class settlement. And without further ado, Business Law 101. The first rule of small business that you need to know is the law of the jungle. Big fish eat little fish. Current distributors operate small businesses based on a contractual relationship with a multi-billion-dollar subsidiary of a large-cap, publicly traded global company that's clearly overreacting to the shifting landscape of the so-called retail apocalypse, and is apparently determined to increase its own margins by feeding on the very sales and distribution network that helped make Pepperidge Farm the crown jewel of Campbell Soup Company. Make no mistake about it. Business competition is brutal. The mortality rate for startup companies is pretty grim. And Pepperidge Farm survived its startup phase not because it offered the best thing since sliced bread. That was already done by the time they opened their first factory in the late 1940s. Pepperidge Farm survived because its original franchisees were pioneers who trailblazed through established retail markets selling the benefits of the direct store delivery model during a time when the emerging supermarket chains dictated terms through their control of the central warehouse distribution model, which is the subject for another talk. For today, suffice it to say that Pepperidge Farm has grown into a very big fish, and that big fish has been tricking and intimidating current owners into voluntarily becoming smaller and smaller fish, who can no longer depend on Pepperidge Farm's corporate coattails for protection because, like so many big fish before it, Pepperidge Farm has embraced predatory practices, which were accurately but incompletely alleged in the employment misclassification complaints. Now that we know the first rule of business, we can't forget that it's important to ask a lot of questions. And you're probably wondering, well, what's the current status of the 3 class action cases? Well, the parties consolidated the cases in a California federal trial court to seek preliminary approval to settle the employment misclassification claims. The next question for many of you probably is, so what? Let the Greek mythology lovers and lawyers figure it out. I want to know, how much money am I going to get and when am I going to get it? Well, not so fast. I wish it was that simple, but it's not. The monetary payoff is only half of the proposed class settlement. As it turns out, the money's tied to the other half of the proposed settlement, which terminates your existing contract and automatically replaces it with the drastically different new form of consignment contract. It's also important for everyone to know that under the proposed terms and conditions of the class settlement, every member of the class, that's all current owners from California, Illinois, and Massachusetts, every member of the class is automatically deemed to opt in, and every current owner who does not properly opt out, quote, shall be deemed to have executed and agreed to be bound by the revised consignment agreement, end quote. So even if a current owner fails to properly opt out or simply does nothing, they're still bound by the terms of the settlement, including the new contract. Even if an owner refuses to deposit the settlement check, Pepperidge Farm will keep half those monies, the other half will revert back to the settlement fund, and that owner is still bound to the radically different new form of contract. So current owners who are members of the class can't just take the money and run because the money's tied to the new form of contract. We've said it many times before, but it's worth repeating here. No one should know your business better than you. Your business is governed by a consignment contract. Therefore, you must know the true meaning and intent of the terms and conditions of your contract because it establishes the rights and responsibility of the parties to the contract. That's you and Pepperidge Farm. Which is why the POAA board is urging every current owner in the country to read the new proposed contract. Determine for yourself whether there are any material differences between the existing contract that you own and the new contract that Pepperidge Farm wants the court to approve. Find out for yourself, are there really new benefits that are being granted to current owners? Are there any new benefits to Pepperidge Farm? Why does the big fish want a new contract with the little fish? We learned the first rule of small business is the law of the jungle. Big fish eat little fish. We also learned that asking and answering a lot of questions can help us develop a sufficiently detailed context to understand the nuances of complex concepts, like the terms and conditions of a new form of contract. And believe it or not, the simple process of asking and answering a lot of questions has a pretty fancy name. It's called the Socratic Method. And it's a common teaching technique used in law schools to promote critical thinking. It's developed by an ancient Greek philosopher named Socrates. And another important thing that Socrates taught us about the Socratic method is that wisdom begins with the definition of terms. Although the U.S. legal system is really complicated, we only need to know that it can be categorized into two basic areas of law: substantive law and procedural law. The substantive law defines how the facts of a lawsuit are handled. Procedural law defines the processes that determine whether or not a lawsuit can even proceed to a trial on the merits, or, in like our case today, whether a pending class action can even settle. Substantive laws touch almost every aspect of our existence, from what information must be on our birth certificates, to the requirement that we be educated as children, to the filing of our death certificates and the disposition of our most precious assets, like our family businesses. There's a substantive law. And the substantive law relevant here is that all three employment misclassification class action complaints contend that Pepperidge Farm instituted unfair policies and practices to control distributors to such an extent that they're actually employees of Pepperidge Farm, and therefore they're entitled to the statutory benefits of employment under the applicable state law. None of the complaints includes a claim for breach of contract. Yet the money to settle the wage-related claims is tied to the proposed new contract. The lawyers argue that current owners need the numerous new and different contract provisions to better protect them from Pepperidge Farm, which apparently will continue its predatory practices without the new form of contract. In our view, that's a pile of poppycock. Anyone who fully understands the material differences among the various existing forms of consignment contract will also know that the proposed revised consignment agreement actually enables Pepperidge Farm to expand the very type of unfair policies and practices that started the employment misclassification lawsuits in the first place. The federal rules of procedure prohibit parties to a class action lawsuit from just settling the case without an order from the court that approves the proposed terms and conditions of the settlement, because it'll impact the rights and responsibility of all members of the class, not just the parties to the case. But for now, you really only need to know that there are three stages to the class settlement approval process: preliminary approval, notice, and final approval. Number one, the parties need the court to grant its preliminary approval of the proposed class settlement. If the court denies its preliminary approval, then the litigation continues. But if the court grants its preliminary approval, move to step two, and the parties must notify every member of the class about the basic terms and conditions of the settlement so they can decide whether to opt in, opt out, or object. After the notice period expires, we reach step three, where the parties then need the court to grant its final approval of the class settlement, at which time the litigation ends. Okay, well, how does the court determine whether or not it will grant approval a class settlement? Well, there are approval standards. The court must determine whether or not a proposed class settlement is fair, reasonable, and adequate. But what does that really mean? Wisdom begins with the definition of terms, so let's define these terms. Fair is a result that affords no undue advantage to either party. It's a balanced and impartial outcome. Reasonable is a relative term that applies to that which is appropriate for a particular situation, for a particular context. Adequate is sufficient. It's equal to that which is required and suitable to the case or occasion being considered, again, to the context. So the court here is going to determine whether the proposed class settlement is fair, reasonable, adequate in the context of the employment misclassification class actions. In addition, the court must determine whether or not the proposed class settlement is the result of fully informed, non-collusive arm's-length negotiations, because, sadly, history's taught us that class representatives and class counsel are susceptible to the vagaries of the human condition, just like the rest of us. Sometimes litigants and lawyers can't escape the impulse to take shortcuts and to not study the context of a case completely. Or even worse, they'll expend effort working secretly with defendants and defense counsel to make a quick buck by agreeing to a bad deal for class members under the guise of fair, reasonable, and adequate proposed settlement. And that's why the approval standards include the requirement that the proposed settlement be the result of fully informed, non-collusive, arm's-length negotiations.